Are you one of the millions desperately waiting for your green card approval? Have you been checking your mailbox every single day, hoping for that life-changing document? What if I told you that the decisions being made right now in January 2026 could either fast-track your American dream or delay it for years? The shocking truth is that some categories have moved forward, while others have gone backwards. And if you don't understand what's happening, you could miss critical deadlines that might cost you everything you've worked for. Hello everyone and welcome to U.S. Immigration Intel. If you are planning to immigrate to the United States, currently living here on a visa, anxiously waiting for your green card approval, or helping family members navigate the U.S. immigration system, then you are in the right place. Today's video is absolutely critical because we are covering every major immigration development that has emerged in January 2026. These updates include green card processing changes, visa bulletin movements, employment authorization document backlogs, new travel restriction policies, and much more. This information could literally change the course of your immigration journey. Make sure you watch this entire video because missing even one piece of information could have serious consequences for your case. And if this is your first time watching U.S. Immigration Intel, hit that subscribe button and the bell icon so you never miss any critical immigration updates. Let me dive straight into what everyone has been desperately waiting for, which is the green card situation. The Department of State just released the January 2026 Visa Bulletin, and the results are all over the place. Some categories saw movement that gave people hope, while other categories actually went backwards, leaving thousands of families heartbroken. Starting with family-based immigration, the F2A category, which covers spouses and children of lawful permanent residents, has shown forward movement of approximately 2 months. For families who have been separated and living in different countries, this is genuinely good news. However, the F2B category for unmarried adult children of green card holders barely moved, advancing only by a few weeks. When you consider that people in this category are already waiting 5 to 7 years, 3 weeks feels insignificant. The F3 category for married children of U.S. citizens also saw minimal movement, just about 3 weeks forward. The most backlogged category remains F4, which is for siblings of U.S. citizens. This category moved forward by barely 2 weeks. At this rate, people who filed petitions in 2008 or 2009 are just now approaching their interview dates. We're talking about brothers and sisters who haven't seen each other in 15 to 18 years. For applicants from countries like Mexico, Philippines, India, and China, the situation is even worse because of per-country limits that create additional backlogs. Shifting to employment-based categories, the EB1 category has remained current for most countries except India and China. For Indian nationals, the EB1 category has actually retrogressed, moving backwards by almost 6 months. This is a major setback for highly skilled professionals from India who thought they had a faster path to permanent residency. The EB2 category for advanced degree holders has also seen retrogression for India and China. Indian EB2 applicants are now looking at priority dates from 2012, which means a wait time of over 12 years. Chinese EB2 applicants are slightly better off but still facing waits of 7 to 8 years. The EB3 category for skilled workers has shown some forward movement for countries other than India and China, but the movement is modest. Indian EB3 applicants continue to face the longest waits with current priority dates going back to 2012. The EB4 category for special immigrants and EB5 for investors have remained relatively stable with current or near-current dates for most countries. Now let's talk about USCIS processing times, which is a major concern for everyone. As of January 2026, there are over 9 million pending cases across all USCIS service centers and field offices. This massive backlog has created enormous frustration and uncertainty for applicants. The agency has stated that they are hiring additional officers and implementing new technology systems to improve efficiency. However, immigration advocates remain skeptical because similar promises have been made in the past without significant results. For I-485 applications for adjustment of status, the current processing times vary widely depending on which service center is handling your case. The Nebraska Service Center is currently processing cases filed in late 2022 and early 2023. The Texas Service Center is slightly faster, working on cases from mid-2023. The National Benefit Center is processing applications from early to mid-2023. These long processing times mean that even after your priority date becomes current, you could wait another 1 to 2 years before getting your green card. I-765 applications for employment authorization documents have also seen significant delays. The stated processing time is 3 to 5 months, but many applicants are waiting 6 to 8 months or longer. This is particularly problematic for initial EAD applications where the applicant cannot work legally until they receive their card. USCIS has expanded their premium processing option to include certain EAD categories, allowing applicants to pay an additional $2,500 for faster processing. However, this premium processing is not available for all categories. I-131 applications for advanced parole travel documents are experiencing similar delays, with standard processing taking 4 to 7 months, depending on the service center. This creates a difficult situation for people who need to travel internationally for family emergencies or work obligations. Many applicants are choosing to file a combination I-765 and I-131 application to get the combo card. However, even these combination applications are taking 5 to 8 months to process. Now let me address the travel ban updates, which have created confusion and concern. In January 2026, the administration has announced modifications to travel restrictions affecting several countries. If you are a national of certain countries or have recently traveled to certain regions, you may face additional scrutiny or restrictions when applying for U.S. visas or trying to enter the United States. The countries affected include some nations in the Middle East, parts of Africa, and certain other regions identified as having security concerns. For visa applicants from these countries, the processing times have increased significantly. Additional administrative processing, known as 2I-21G, is being applied to a higher percentage of applications. This means that even after your visa interview, you may have to wait several weeks or months for additional security clearances. Some applicants are waiting 3 to 6 months or even longer. This is particularly challenging for students who have deadlines to start their programs or workers who have job start dates. For green card holders and U.S. citizens who are nationals of affected countries or who travel to these regions, there are also implications. While U.S. citizens cannot be denied entry, they may face enhanced screening and questioning at ports of entry. Green card holders from certain countries are being subjected to more intensive secondary inspections. Immigration attorneys are advising green card holders to carry extensive documentation of their ties to the United States, including proof of residence, employment, tax returns, and family connections. Let's talk about visa interview wait times at U.S. consulates and embassies worldwide. The situation has improved compared to the pandemic era, but significant delays still exist in many countries. For B1, B2 tourist and business visitor visas, wait times vary dramatically by location. In countries like India, Mexico, Brazil, and Colombia, applicants are facing wait times of several months just to get an interview appointment. The U.S. Embassy in India has been working to reduce backlogs and has opened additional interview slots, but demand far exceeds capacity. For F1 student visas, the State Department has made efforts to prioritize these cases, especially during peak season from May through August. However, students applying outside the peak season or in high-demand countries are still experiencing delays. The recommendation is to apply as early as possible, ideally 3 to 4 months before your program start date, to account for potential delays. H-1B visa holders face their own set of challenges. The H-1B visa stamp appointment wait times at consulates in India and other high-demand countries can be 3 to 6 months. This creates a problem for H-1B workers who need to travel internationally and return to the United States. Many H-1B holders are choosing to avoid international travel altogether rather than risk being stuck outside the United States for months. The Domestic Visa Renewal Pilot Program, which allows certain H-1B holders to renew their visas without leaving the United States, is still in limited pilot phase. Now let's discuss some positive developments. USCIS has announced that they are expanding online filing options for more form types. Previously, many immigration applications could only be filed by paper, which created additional delays. Now, more forms, including certain family-based petitions and employment-based applications, can be filed electronically through the USCIS online account system. Electronic filing has several advantages, including instant confirmation of receipt, ability to track your case online, faster processing times, and easier communication with USCIS. Another positive update is regarding work authorization for certain visa categories. USCIS has extended automatic work authorization extensions for certain applicants who file timely renewal applications. This means that if your EAD is expiring and you file your renewal application before it expires, you may automatically receive a 180-day extension of your work authorization while your renewal is pending. This automatic extension helps prevent gaps in employment authorization that were previously causing problems for workers and employers. For H-4 visa holders who are spouses of H-1B visa holders, the H-4 EAD program continues to be available. H-4 spouses whose H-1B spouse has an approved I-140 immigrant petition or has been in H-1B status for 6 years or more can apply for work authorization. The processing time for H-4 EAD applications is currently 4 to 6 months, depending on the service center. Let me address some common questions that many people have. One frequent question is whether it is safe to travel internationally while having a pending green card application. The answer depends on your specific situation. If you have a pending I-485 adjustment of status application and you travel internationally without advance parole, your I-485 will be considered abandoned and denied. Therefore, it is absolutely critical that you obtain an approved advance parole document before traveling if you have a pending adjustment application. Another common question is about changing jobs while on an H-1B visa or while having a pending green card application. For H-1B holders, you can change employers, but your new employer must file a new H-1B petition for you. You can start working for the new employer as soon as they file the new H-1B petition if you are maintaining valid H-1B status. For those with pending green card applications based on employment, changing jobs can be complex. If your I-140 has been approved for 180 days or more and your I-485 has been pending for 180 days or more, you may be able to change to a same or similar job using AC-21 portability. So friends, this has been a comprehensive overview of the major immigration updates for January 2026. We have covered green card processing, visa bulletins, EAD and travel document delays, travel restrictions, visa interview wait times, and practical advice for navigating the immigration system. The U.S. immigration system is complex and constantly evolving. Remember that every immigration case is unique, and the information I have provided is general in nature. For specific advice about your particular situation, you should consult with a qualified immigration attorney who can review your case and provide personalized guidance. If you found this video helpful, please give it a thumbs up and share it with your friends, family members, or anyone else who is navigating the U.S. immigration system. Your share could help someone who desperately needs this information. Make sure to subscribe to U.S. Immigration Intel if you haven't already, and hit the bell icon so you get notified whenever we post new videos with immigration updates, tips, and guidance. We are committed to bringing you accurate, timely, and useful information to help you on your immigration journey. If you have questions or topics you would like us to cover in future videos, please leave a comment below. Thank you so much for watching U.S. Immigration Intel. I wish you all the best in your immigration journey and hope that you achieve your American dream. Stay informed, stay patient, stay hopeful, and most importantly, stay legal. Take care and see you in the next video.